I'd like to bring the June 27th meeting of the Complaint Committee of the Sunshine Ordinance Task Force to order. It's 5:30. Clerk, please call the roll.
On the call of the roll, Member Wolf.
Present.
Wolf present. Member Hinsey.
Present.
Hinsey present. Chair Tesfa.
Present.
Tesfa present. We have a quorum, and there are no agenda changes that I know of at this time.
Thank you. Can we move to item number 2?
Item number 2. Item number 2.
Wait.
It's up to you.
Do we need to take public comment on item number 1? Do we take public comment on item number 1? Let's go back to item number 1. Is there any public comment on item number 1? That is the call to order, roll call, and agenda changes.
I would like to move this item, which is last on the agenda, further up. I flew in from the East Coast. Don't really know the reason for this meeting. Don't think it'll be too beneficial, but I have a plane flight at 8 o'clock. So if you move it up, I can go back east.
Thank you for the public comment. We'll move to item number 2.
Item number 2.
I'm sorry.
Item number 2.
Are you going to move it up?
I took public comment on the item. I'm not taking any action.
Item number 2, approval of the May 23rd, 2017 Complaint Committee meeting minutes.
Do we have a motion?
Move to approve the minutes.
Second.
Is there public comment on that motion? Being none, can we take that by acclamation?
Yes, the motion is approved without objections.
Thank you.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Members of the task force, I object to the late night emails that I received from Bruce Wolf between 10:30 in the morning and 4:30 a.m. Pacific time. I've noticed him repeatedly not to contact me during that time. He had continued to do it. He didn't answer any of my questions. So I filed 2 police reports on him, an ethics complaint, and a whistleblower complaint. These are called ex parte communications. You should not be communicating with me at all in the first place.
Thank you. Is there any other public comment?
Yes, I'm unclear on the process of this public comment, and because I don't want to miss
This is for comment on things that are not on the agenda.
I see.
You have items that are on the agenda, and you
I
can
do.
speak when we get to those items.
Okay.
Thank you.
Is there any other public comment? Seeing none. Can we move to the next item?
Next on the agenda is item number 4, file number 17039, complaint filed by Thomas Bussey against the San Francisco Public Finance Authority for allegedly violating Administrative Code, Chapter 67, by failing to notice and conduct public hearings and failing to respond to requests for public records. I'd like to state that the clerk of the board did request that the matter be continued to a future meeting as she is conducting research. And due to issues with the budget cycle, she was not able to get her answers to her questions. And so the clerk of the board did request a continuance, and Mr. Bussey was informed of the fact, and my assumption is that he was informed and did not appear today.
Thank you. Is there a motion on this item?
I'll motion to continue the matter to the July meeting of the Complaint Committee.
Okay. Is there a second?
Second.
Is there any public comment on that motion? Seeing none, can we take that by acclamation?
The motion is approved with no objections.
Thank you. Let me just...
The following complaints are before you for determinations The complaint committee shall review file numbers 17055, 1056, 17057, and 17058, determine if the Sunshine Ordinance Task Force has jurisdiction, and determine if the requested records are public pursuant to Administrative Code Section 67.21E. The complainant and respondent were not required to attend today's meeting, but they were invited to attend to provide comments if they wish to do so. A hearing on the merits of the complaint will be scheduled on a future date if you do determine that we have jurisdiction. First on this portion of the agenda is item number 5, file number 17055, complaint filed by Dente Tedeschi against Donna Atkins and the Mayor's Office of Disability for allegedly violating Administrative Code Section 67.5 by restricting access to public meetings.
Is the petitioner present? Okay. Clerk, can you give the petitioner 3 minutes to explain your case, and please focus on which section of the code that you are bringing your action?
And could we also focus on jurisdiction?
Right.
Okay, so the section is 67.3, and this is the section that has jurisdiction over public meetings. And I was on April the 17th, 2017 of this year, I was attending a SFMTA board meeting when I was stopped by sheriff's officers at the security gate and questioned about why I don't have my service animal on a leash. I said that my service animal is a service animal, and in fact that I have a choice of having my service animal off leash if it's for my safety or for my service animal's safety, as long as my service animal is under my control, which she was under my voice control. This is part of ADA. It's a central part of the of having your service animal under control. They then I had previously had no issues with that coming into the building. This is the first time that I was completely stopped and said that I was not able to attend this board meeting. They then called the Mayor's Office on Disability, talked to Donna Atkins, who then responded that my response on the second question, on the question of if your service animal is a legitimate service animal. The second question is, what task does your service animal provide? I responded, nonviolent protection, which is a task under ADA policy. And for that question, these sheriff's officers specifically asked Donna Atkins if that is a valid task. She said no. I was then informed that due to my answer of nonviolent protection of my service animal in terms of what the task that my service animal provided for me, I was unable to attend the meeting. I protested. I was in distress. My service animal was on my right, just sitting down, didn't even move, didn't bark, didn't do anything. There's nothing. There was nothing that she did for them not to have me go forward and attend the meeting, and they prevented me from attending a public meeting.
Okay.
Sorry.
Which section? You said 67.3.
Yes.
That part of the ordinance is just definitions.
Okay.
So because we're focusing on the issue of jurisdiction, I want to know which section of the Sunshine Ordinance you're bringing this item under.
Can I? Is it possible to ask for more time in answering that question? Because I was under the understanding that this was just a preliminary hearing, just to.
It is. So we need to figure out if we have jurisdiction to listen to this matter at all.
Okay.
And so I'm trying to find out which portion of the Sunshine Ordinance you're bringing your complaint under that we have authority to even adjudicate a matter like this.
So I guess it's the public access to meetings.
That would be 67.5.
Okay.
Okay.
And then I would like to, thank you.
Okay.
I would like to hear from the respondent on this initial issue.
Sure.
Okay.
Hi, I'm Nicole Vaughn, representing the Mayor's Office on Disability. What may I clarify?
Right now, we're trying to figure out if we have jurisdiction over this matter. Does the mayor's office have any concern about jurisdiction on this matter by the Sunshine Ordinance Task Force?
The Mayor's Office on Disability is unclear how this falls under the Sunshine Ordinance Task Force.
Okay, thank you. Are there any questions on jurisdiction from our members?
Yeah, I have a question for the complainant.
Member Wolf?
Mr. Tedeschi, is that
Yes.
how you pronounce it?
Yes.
So was it a matter of just entering the building, or where were you trying to go? Were you trying to attend a meeting? Or?
Yeah, there was SFMTA board meeting on April the 17th. This is the same day that I was there for. I was
Okay.
there for a 1:00 meeting, and I was unable to attend that particular meeting, which was very important to me,
But-
regarding, again, my service animal in the situation that I have with SFMTA.
Okay, just wanted to know
Yeah.
because that helps us understand whether this
Sure.
is a
Sure.
Did you
Member
actually-
Hinsey?
Did you actually enter the building?
I cleared the security, and that's when I was stopped because my animal was off leash.
Okay.
I have another question.
Member
Yeah.
Wolf?
So you mentioned, you testified that you've entered the building before
Previous to that.
with the same set of conditions, your service dog being off leash under full voice control.
Yeah, I was challenged once, and one time before, and I explained to them, and I showed them the paperwork that has service animal and my rights, and they never asked me that second question, and so I was then allowed to proceed.
And you were able to come into the hearing, any of the hearings that you were?
Yeah, exactly.
Okay, that
exactly.
you were there for?
This
that
particular
purpose.
time was when they went a step further and asked me the second question: what tasks does my service animal provide? And when I responded nonviolent protection, that's when they still challenged me. And then when I still protested, that's when they made the call into MOD. And MOD's response was that nonviolent protection was not a task, and therefore that's why I was unable to attend.
Okay, thank you very much.
Yeah.
Ms. Atkins? Are you?
No.
You're not Ms. Atkins?
No.
So are you here on behalf of Ms.
Yes.
Atkins?
Yep. I'm the Director of Mayor's Office on Disability.
I understand that, but, okay, so I understand that. Gets us confused is when the actual respondent is not here, when they're actually named.
Right.
So that's, but it's also names the office itself, so either way. Okay, thank you. I'd like to ask you a question.
Oh.
Yeah. So, Mr. Tedeschi is stating that he has been able to freely enter the building at previous times. That he's been able to go to public hearings at previous times. So he just testified that either someone from your office or your office had stated that his reason for having a service dog was not acceptable under your determination. How did you come to that conclusion?
So, first of all, I want to clarify that I'm not sure that the Mayor's Office on Disability spoke to any of the security guards on that particular date. I think Mr. Tedeschi mentioned April 17. Mm-hmm. And as far as I'm aware, we did not speak to the security guards on that particular day. So I don't know if that changes the tone of your question, or if you'd like me to move forward.
Well, I'm just trying to corroborate what he had just testified. He said that somebody from the Mayor's Office of Disability had claimed that his reason of not quote unquote nonviolent protection was not a task. Was that an actual determination that came from the Mayor's Office of Disability?
No, not to my understanding. So we've since clarified that nonviolent protection does qualify as a task, but the matter at hand is that we need to see if the animal is indeed a service animal under ADA, we need to know exactly what that animal is trained to do. Regardless of that, we also need evidence that a particular service animal is under behavioral control. And if there is concern that a service animal, whether it is a service or support animal, is or is not under behavioral control, then we have the ability to say if the animal does not appear to be under behavioral control, that the animal may be removed.
Okay, thank you.
For the complainant,
Yeah.
that's you. So she has a question for you.
Did the security guard ever ask you if your service animal was under behavioral control?
No, they didn't. No, they did not. Again, this was a specific thing that the sheriff's officers told me that they called the Mayor's Office on Disability. I have another case in which the Mayor's Office on Disability actually responded that nonviolent protection is not a task. I have this on email. I have proof to show you in a later date what I'm talking about. This specific bylaw, people are allowed to ask you two questions. Is that a service animal or is it a pet? I responded, it's a service animal. The Mayor's Office on Disability has a long record of me saying that my animal is a service animal, so that should not be even in question. Number two, the second question you are allowed to ask a person is, what task does your service animal provide for you? And my response was a nonviolent protection. And after that, I further also explained in my long tirade while I was at the gate was that as long as my animal is under my control, if my animal is running around, if my animal is defecating, if my animal is barking or threatening people, then I can understand, then they have a right to not let me enter. But the main law in ADA is that your animal has to be under control. Behavior control and all that stuff, I am unaware of those terms, but this is a specific thing in ADA, which I will show you on a later date, proof of. I've even called ADA.gov, I've talked to them. Nonviolent protection is a task. And that is, by law, that is all that someone can question you about.
Thank you. And also, we don't have jurisdiction under the ADA, just to make that clear. Member Wolf, do you have a question?
Yeah, I was just going to say that and then follow up by saying that it doesn't, from the testimony we just heard from the Mayor's Office of Disability, they had no involvement with this particular action directly.
They did. And I have email proof to show you that.
For these dates?
For those dates, exactly.
For those dates.
I have proof.
Were they submitted for the record?
I didn't think that was part of this part. I thought that was part of when I come in on the second, to show you.
Fair enough. Fair enough.
Well,
so
it is part. The only reason it's part of this part is that we are supposed to determine that you have all of your documents in order, all of the facts in order.
I do.
We're not going to make a determination that it was a violation or not.
Okay.
But we need to be able to see this documentation that you're saying of.
Can I show you my emails that I sent, or how can I do this?
Well, I mean.
Is it in the package? Is it in our package right now?
It's not.
No.
Okay.
No.
Yeah, our job is to kind of prepare the full task force with the full complement of information regarding the cases, so they don't have to be investigating on the fly.
But what Ms. Bond said is completely misleading and completely not correct.
And you have proof of that?
And I have proof of that.
Okay. So,
Okay, I think at this.
And I have it right now as well.
I know,
if you
but the
give me
thing
a
is,
chance.
it needs to be in the packet so that she would have had an ability to inspect that document while she was in her office to
She
say.
has my emails. She has all the information.
But-
It's emails that I went to her and to Miss
Right,
Donna
but for
Atkins
evidence
as well.
to be used, it needs to be in the packet so that we can make reference to it. Right now, I am inclined to continue this item to our next meeting. All documents
Okay.
need to be in the packet that's in the record.
Okay.
That has been posted publicly.
Okay.
On the agenda, so that all of the public has had an opportunity to see
Okay.
this.
Okay.
But before we let you go, I would
have
like
a-
to just make sure that we have told you everything that we need.
Yes. I
So
will.
in this case, because we're talking about a violation that would be under section 67.5, one second.
I would also say 67.13, barriers to attendance.
Okay. So what I would like you to do is just take a look at section 67.5 and
Okay.
67.13
Okay.
and determine what items of evidence that you have in your possession
Okay.
that support a claim under that.
Okay.
Make sure and send those to Victor, and he's going to calendar you for our next complaint committee meeting.
Okay.
I think it would also be helpful in this case, and it sounds like you already have this, but just as a reminder, any documentation that you have that the Mayor's Office of Disability was
Okay.
involved in this encounter. You said
Okay.
the Sheriff's Office called.
Yes.
You have some, or you have maybe an email referencing the call later on or something like that.
Okay.
So include that in the packet. Is there anything else that the members think would be helpful for the complainant to include so that we can help this case move forward?
Not in terms of a sunshine.
Okay, but only what we have jurisdiction over, which is sunshine, so, okay.
So move to continue.
Yes, is there a motion to continue this item?
I'll move to continue this item to the July meeting of the complaint committee.
And do you want to just provide, as part of the motion, the instruction of what's needed from either or
Sure.
both parties?
That the complainant provide evidence supporting his allegation that MOD is in violation of 67.5 and 67.13, including evidence that they were involved in his encounter with the sheriff on April 17th.
Okay. Yeah.
Okay.
I got it. Thank you.
Is there, so we have a second on that?
Yeah, I
Okay,
second.
can we take that by acclamation? Okay, so make sure and send those documents to our
Public
clerk.
comment.
Okay.
Oh, is there public comment on the motion? Nope, okay, seeing none, we'll take that by acclamation. Just make sure those documents are with Mr. Young via email.
The motion is passed with no objection, and this matter will be continued to the next meeting of the complaint committee.
Thank you.
Thank you.
Next on the agenda is item 6, file number 17056, complaint filed by Dente Tedeschi against Candace Carpenter and the Office of Citizens Complaints for allegedly violating Administrative Code, Section 67.21, by failing to respond to a public records request in a timely manner. They have provided a written response. The respondent has provided a written response, which is in your packet.
Can we hear from the complainant? Can we give Mr. Tedeschi 3 minutes, please?
Okay, this is another case of I was arrested for not signing a citizen's arrest ticket in January 14th, 2016. I was then taken to the jail and placed in for 3 days in a suicidal hold, or in a 72-hour suicidal hold, because I said I didn't have my service animal with me. I complained to the OCC about this date and this situation, the fact that I had called the police officers for help due to a community ambassador. And I found it incredible that because of my request for a police report on that particular date, I was denied. And then the only way the police officer said I was able to get a police report was the only way that I was going to do it is if the community ambassador files a citizen's arrest on me. She did, and like I said, I was arrested, and for the first time in my life, never been in jail. And not only that, I was placed in 3-day hold because I said I was suicidal, like I told you. After the OCC complaint, I didn't hear anything back from them, only until the SFMTA hearing that I have on another agenda on this. The same date I left the SFMTA hearing due to the city attorney's office starting to ask me if I had a legitimate service animal. And so I left. I walked out of the meeting. I come home. I get the email from the OCC saying the complaint that I had lodged back in February of 2000, or I'm sorry, back in January of 2016 was complete, and that I had an option of appealing that decision. I appealed it right away. I then asked for a review of the decision. I never got an answer to that review for months. I said I have a right to I have a right to the footage. I haven't been able to get the footage from either U.S. Bank or the OCC. I went to the OCC. I had a review at the OCC. We started talking about they wouldn't even let me see my own record or any of their notes, period. And unless I signed this declaration, I had questions on that declaration, and the time limit had expired. So I have no idea how they came to that.
Okay.
So.
Is there anyone here appearing on behalf of the respondent? The Office of Citizens Complaints? Okay. I have a couple of questions for the complainant. So for clarification, which portion of the Sunshine Ordinance are you bringing this complaint under?
The public information and public records.
But which section? 67 point?
67 point...
It says here, well, in the complaint summary, it says simply 21.
But it's unclear if that's correct.
67.21? Is that what
It's unclear if that's correct, though. Did you submit a request, an immediate disclosure request, a request for records? What kind of request was submitted?
I did. On emails, I have emails. I requested to review my case and how they came to it.
Okay, so it was a regular request.
Correct.
Okay.
Correct.
And then these were your records that were pertaining to the citizen's arrest that you were put under?
Yes.
Okay, from the neighborhood ambassador.
From the police officer refusing to give me a police report because she just said, the whole issue started was...
She wouldn't give you a police report about your own arrest?
Of my own? No. She would not give me the police report for the incident that I called them about. Okay. And just said, just leave. And when I left, I came back and I said, no, I really need a police report.
And they said, you have to get arrested to get a police report.
And so she turned to so the police officer turned to the community ambassador and said, the only way he's going to get a police report is if you file a citizen's arrest on me. And so she did that, and then I refused to sign the ticket because I just knew, I thought it was crazy how that was. And so then I ended up because I refused to sign the citizen's arrest ticket, I was placed in jail.
Okay, so are you requesting documents regarding the citizen's arrest ticket or the initial police report?
For the initial police report, by the way, I did get the police report, and I also get the CAD report, but it's heavily redacted. I mean, heavily redacted. It's not only the names and the addresses, but the comments. Part was heavily redacted, and so then when the complaint was responded to formally by denying the complaint, I then was requesting to see the footage, which I haven't been able to get. I was the one who requested the footage from the U.S. Bank myself. They won't give it to me. OCC won't give it to me.
So you would like the footage from the incident of your citizen's arrest?
Yes, ma'am.
Citizen's arrest or the initial police report?
The
Footage of-
the citizen's arrest.
Okay.
When I was arrested,
I'm just trying to
there's-
get an idea of what you're looking to get, so
Sure,
that we
sure.
can. Okay, so the citizen's arrest.
Correct.
Notes or interviews given in the case of that arrest.
Correct.
And so this is the arrest that occurred at the police station,
No, it happened at the location, U.S. Bank.
which was the location of the initial incident that had a police report.
Correct,
So
correct.
after you asked for the police report at the station, did not receive it, you went back to the scene of.
No, I was at the location. I called the cops because of this confrontation with the community ambassador. The cops came. I then asked for a police report for that incident, and I was refused. And when I demanded one,
But there, what was the? Okay,
So
I'm
I
struggling
would
a
just
little bit.
say there are two things that are happening here. First was his initiation of a citizen's arrest.
On himself.
No, on someone on some other incident. Okay, and then right, is that correct?
the community ambassador had no idea about citizen's arrest. It was only because
No,
of
what you initially filed a police report.
Yes. No, I filed a OCC complaint against the
OCC
officer.
Against the officer.
Correct.
Okay.
Correct.
Not the citizen's ambassador, the police officer.
No.
Okay.
Against the San Francisco police officer for improper arrest and improper handling of the whole situation.
And what you were attempting to go to, where were you when the citizen's arrest happened?
I was on Van Ness and McAllister at the U.S. Bank, and the U.S. Bank has video footage of the whole incident, which I wanted to have to review for myself because my allegations were that the community ambassador was threatening me.
Who the community ambassador works for who?
She actually said that she not only works for the city, but she also works for U.S. Bank.
What's her purpose of being at that bank?
Providing security, I guess.
Security? Like a security guard?
Yeah, this is what she told me, and this was around when the football, when the NFL was here.
Oh, when the Super Bowl.
Super Bowl was here.
So with regards to U.S. Bank,
Yes.
U.S. Bank, we don't have jurisdiction over that. That's not a public venue.
Yes, I understand, but the OCC has the footage. Based on my complaint, the OCC has footage from the bank.
I understand. So you're trying to get the information from the OCC.
See, exactly.
Gotcha.
Exactly.
Okay.
Exactly.
So we have to keep this confined in the city government.
Okay.
That's the only way that this works.
Okay.
Private locations don't apply unless they are under city contract or something like that.
Okay.
So that's the first thing. So the incident happened at a private location.
Correct.
Something happened. You were arrested.
I was arrested. Yes.
Okay. All the evidence was collected from the private location.
Correct.
You're
Correct.
trying to get that information.
Yeah, I want to come up with how they completely dismissed everything.
Okay. The Office of Citizens Complaints.
From the Office of Citizens Complaint. Correct.
Okay.
Correct.
Gotcha. Okay.
Correct.
So this sounds like that if the information is in the possession of the Office of Citizens Complaints, then it's public information.
Right.
Okay.
So I think we have jurisdiction over this item.
Redacted or otherwise, that comes later. Okay. And the fact that this took place in front of a commission, then that provides the jurisdiction at the same time. I just want to read through the. Victor, did anybody from the Department of Police Accountability or the Office of Citizens Complaint, did they respond about attending today?
They were not required to attend today because we're only determining whether or not we have jurisdiction and
got
define if we have, and to make determination regarding the 45-day rule.
Okay, got it. Perfect. Okay. All right. So, so with that, I would find jurisdiction and that the information is public.
Okay. Do we have a
I would-
second to that?
I'll move that.
I'll second it.
Okay.
And also to continue it to our next meeting.
Continue it to next meeting.
Okay. So we have found jurisdiction. I would like to continue this item to the next meeting of the complaint committee. Do we have a motion?
Yeah. I
Motion's
moved
up.
it.
I thought that was just to find jurisdiction.
I think he added.
Oh,
I think he added.
to include the
You did? Okay.
yeah.
Can we take this by acclamation?
Public comment.
Do we have any public comment on that motion? Okay, seeing none?
The motion is passed without objection by the committee.
Okay, thank you.
Next on the agenda is item 7, file number 17057, complaint filed by Dente Tedesse against George Cawthron and Robin Wright, Office of the City Attorney, for allegedly violating Administrative Code, Chapter 67, by failing to protect the rights to privacy of a member of the public.
Sorry.
There is a response from the respondent in the file.
I would like to hear from the complainant, if you could give him 3 minutes. So please focus on which section of the Sunshine Ordinance you're making reference to on this privacy issue. Which portion of the ordinance gives you this this right to privacy?
I'm not ready for that particular. Can I? It is basically privacy of my own protected information. So it was basically giving. It has to do with.
Okay. How about we'll give you 3 minutes, then you can tell us what you have at this time.
Okay. So what this pertains to was the SFMTA banned me for 5 years from riding the cable cars due to my service animal not being on my lap. The notice that I was given by John Haley by email was on February 2nd. I responded right away that I intended to appeal. So there's no reason for the city or city attorney's office to then physically come to my address and give in a folder the ban, because it wasn't taped, it wasn't securely contained. And so my building manager, who I've had an issue with prior to this, had presented it to me, and right after that, before I was even allowed to appeal the revocation, the San Francisco Chronicle got a hold of that the very next day and published it. I didn't know that it was George Cawthron, a city attorney, a city investigator, chief investigator of the city attorney's office, was the one who actually gave my file to my public housing coordinator to give to me, because I wasn't there. And so I suffered an invasion of privacy, number one. Number two, if it's a question of notification, I already notified them that I actually intended to appeal. So I have that proof also with me. So I shouldn't even have gotten that. Next also was I then tried to email George Cawthron when I found out it was actually him who actually emailed me, who actually delivered the revocation. I was then banned by Barracuda Systems from even emailing him. So I personally went to his office, and he said that this was public information. He said that due to my not being there, he gave it to my housing coordinator. And I found that as an invasion of my privacy. I have a right to privacy. I have a right to appeal. I felt that in itself kind of compromised my appeal in the whole process, because it was then published in the newspaper on the same date, which was February 7th.
Okay. Thank you. Is there anyone present on behalf of the respondent? No? Okay. Are there any questions from the members for the complainant? Member Wolf?
Who delivered that document to you, or to your location?
George Cawthron, Chief Investigator for the City Attorney's Office of San Francisco.
All right, thank you.
And all I requested was that it be sealed, and it wasn't. And in fact, 2 days after that particular incident, besides the San Francisco Chronicle finding out about the whole issue, I was actually locked out of my house.
Okay, thank you.
Okay, sorry.
We're just trying to determine whether this is within our jurisdiction.
Okay.
Because the city attorney is disputing that.
Yes, I know.
This is a concerning case, but I do not know which section of the Sunshine Ordinance gives us. Okay, so can you?
So it would be 6724D under law enforcement information. The last sentence of the first paragraph says, notwithstanding the occurrence of any such event, individual items of information in the following categories may be segregated and withheld if, on the particular facts, the public interest in non-disclosure clearly and substantially outweighs the public interest in disclosure. And I'll jump down to number 2, which is in a bullet list of 6. It says personal or otherwise private information related or unrelated to the investigation if disclosure would constitute an unwarranted invasion of privacy. So I'm not quite sure. We don't have legal counsel here, and I mean,
the city attorney is not a law enforcement agency. So, and I thought George Cawthron was an investigator for the city attorney.
But he was delivering a ban, which.
But the city attorney is not a law enforcement agency. If it was the district attorney's office, then I would have a different.
But this is not about a law enforcement agency. It's about law enforcement information. So I'll have to start at the top of this paragraph.
Okay.
The district attorney, chief of police, and sheriff are encouraged to cooperate with the press and other members of the public in allowing access to local records pertaining to investigations, arrests, and other law enforcement activity. However, no provision of this ordinance is intended to abrogate or interfere with the constitutional and statutory power and duties of the district attorney and the sheriff as interpreted under Government Code Section 25303 or other applicable state law or judicial decision. Records pertaining to any investigation, arrest, or other law enforcement activity shall be disclosed to the public once the district attorney or court determines that a prosecution will not be sought against the subject involved, or once the statute of limitations for filing charges is expired, whichever occurs first. And then it goes on to this bullet list that I just iterated. So I somehow get the feeling that it may fall under this, but without legal counsel to provide some analysis, and because this is not the city attorney, this is district attorney. Gotcha. Okay. Well, the question.
That's my concern. Is the jurisdiction issue?
Then I have another question.
Yeah.
Was let's see, who is this person's name?
George Cawthron.
George Cawthron. So
yeah,
he hand delivered this.
He hand delivered this.
And was he a service? What was his role in delivering it?
The email that I got on the 2nd of February said by email and personal delivery. I also got on the 24th of the same month. I mean, weeks later, I got by mail the same notice, but it was on
certified mail.
Certified mail without the signature. Nobody signed for it.
So what is your contention about Mr. Cawthron?
My contention was that because of his service, which if he says it's actually to deliver that information, I already responded that I got that information and that I intended to appeal on the 2nd of February.
Did he say who ordered him to do that? Did he say if he was acting on behalf of?
He was acting on behalf of SFMTA.
Oh, okay.
SFMTA and John Haley.
Okay, so it sounds like, Madam Chair, it sounds like that he was acting as a, what do they call it? When a person who serves.
As someone who serves process, but it wouldn't, a process server to find jurisdiction would need to be acting as a process server on behalf of the sheriff or the district attorney's office.
I'm wondering if there may be some automatic extension of that from the city attorney's office.
And then the reason that I also listed Robin Wrightses was because of, at the end of the appeal, she was the one who brought this complaint forward. She was the one who represented SFMTA at my appeal hearing. I felt that because of this news leaking out, I didn't leak it to the papers. Not only was I automatically disadvantaged, but actually I had people coming up to me and saying, "Man, I heard that you were banned for 5 years. That's messed up. Blah blah blah." You know, it just cost me embarrassment. It cost me humiliation, and it wouldn't have occurred if this not had happened. I can understand maybe if after my appeal, after the decision was actually denied, for that to happen. I guess I would understand that. But I didn't even have a chance for that appeal process to take place.
Yeah.
Got it. So I just give us a moment for
Sure.
a second. So reading the communications from the city attorney's office under the factual summary.
Yeah, that's on page 6 of the packet, right?
Right.
That's what I've been looking at.
Right. So there it says that the SFMTA didn't have Mr. Tedeschi's address to serve him with the decision. So the city attorney's office located. So they must have contacted the city attorney's office. Victor, do you know if the SFMTA uses, because it's an enterprise agency, does it use its own legal counsel or does it use the city?
I'm unaware.
You're not aware. Okay. That would be a good question to ask, because how would the city attorney's office know about any of this, you know, in that kind of way? We just need to talk amongst each other for right now. Thank you. That would be my first question in this. I think it's worthwhile to continue this case and have somebody from the city attorney's office appear. I mean, the letter is quite factual, but I think the question then becomes is if the city attorney is joined as a party to the respondent because of their activity, versus, you know, this person was he just ordered to deliver it, and he had made no decisions on whether it's correct or not?
George Cawthorn maybe serves in different types of roles.
Right. So I think
Or
that
might have been serving in a role outside of, or participating in activities outside of his usual role, in this case, of delivering because if he's an investigator, why is he delivering?
Right. And I don't know whether it's his responsibility in that role to take notice if something should be sealed or not be sealed, and to bring it up. I think those questions, you know, might be important and then the question of whether this is or is not a law enforcement information. And
So as a point of order at this time, it sounds like we're trying to figure out if we have jurisdiction. I don't know if we can actually find jurisdiction without continuing the item to get more information.
yeah.
So we can continue it, and I can forward your questions to their office so that they'll be ready to respond at the next meeting.
That would be great. Thank you, Vic.
Yeah.
Thank you, Clerk. Okay, do we have a motion at this time?
I'll move to continue this item to the next meeting of the complaint committee.
Do we have a second on that?
I'll second it, but I'd like to amend the motion.
Adding that Victor sends the questions to the...
I don't think that's an issue regarding determining whether or not the record is public, because it's a I believe the question is whether or not it should have been sealed or not.
Right. So I think, well, so then,
We've already found that this document is public, but we're trying to figure out if we have jurisdiction to determine if there was a violation by not sealing the document under section 67.21.
right, and and then the question then becomes whether this particular respondent was responsible to assure of that. That's just the question, not
Yes,
a
just a
judgment.
question. I will forward them copies of this audio for their review.
Thank you.
Do we want, but we want them to attend.
As well as appearance.
Oh, yes, they are required to
Okay.
attend next meetings.
Great.
Do we have any public comment on this motion?
I think there are two issues that you're kind of stumbling over. First off is the service of papers. The chief investigator was supposed to personally serve the complainant. That's the law. And if you read the proof of service, he noted that he served so-and-so who was a manager, and he also did note that the letter was unopened. So that would be a legal issue that would have been brought up in a legal proceeding had the complainant known the law on that issue. The second one is that the complainant contacted the chief investigator. That was an admission that he was served. So these are all peripheral things that have nothing to do with the Sunshine Ordinance. But the fact that the city attorney isn't here, they're not able to address it. So I think it should be put over.
Thank you. Is there any other public comment on that motion? Seeing none, can we take this by acclamation?
The motion passes without objection.
Thank you.
Next on the agenda, item number 8, file number 17058, complaint filed by Dente Tedeschi against John Haley and Tom Nolan, San Francisco Municipal Transportation Agency for allegedly violating Administrative Code Section 67.21 by failing to respond to requests for public records in a timely and or complete manner.
Clerk, can you give the complainant 3 minutes, please?
Okay, so all these issues seem to be tied in somehow. So my apologies for taking all this time. The issue here is that I had repeatedly asked for records of the 2016 rules on cable cars with service animals. I got one. What I'm contending is they never had this rule, in fact, in place in 2016, saying that if you are riding on the outside of the cable car, on the historic cable cars, you have to have your service animal on your lap. It wasn't there, period, for 2016. Because of my issue, because of the public and media attention back in October 29th, 2016, that this case received, in which my service animal was actually on my lap, they retroactively then created this rule saying that you have to have your service animal on your lap for 2016. That was not the case. I actually have proof of that. I just wanted to have Tom Nolan or John Haley meet with me regarding this. They refused any meetings. They refused any requests. I made numerous requests to actually meet them to discuss this issue. I also have proof that the website was changed on January 6th, 2017, to reflect this new rule. So in fact, it shows the proof that this 2006 rule was not even in place. I requested proof of that particular policy from the accessibility department of SFMTA and also from the director of transportation. I've gotten one policy directive from the director of transportation's office only, not the accessibility department, and it was even signed without his name. Somebody else signed for him for that particular one. So the issue is on 2016, the policy regarding service animals and the historic cable cars riding on the outside, and this new lap rule that they implemented.
And so in this, thank you.
Yeah.
Are there any speakers present on behalf of the respondent? Okay, seeing none, we can proceed to questions. Do the members have any questions for the complainant? I do. So just to clarify, the documents you're looking for here are the previous policy, which did not state that dogs need to be, service animals must be on the lap,
Exactly.
that had been published at the time of your incident.
Exactly. And specifically from the accessibility department, to show proof that rule wasn't. I have emails from Virginia Rathke, Senior Transportation Planner for SFMTA, regarding this, and it
That's
never.
okay. So, but you would like though as a copy of this policy from that date? I'm just trying to determine
correct.
right now
And then
if
also-
we have jurisdiction and that the document is public. That's
Okay.
what I'm trying to determine.
And then also the fact that I wanted to have meetings, I wasn't able to get meetings with them. Period.
Okay.
As well.
Thank you. Are there any other questions? Okay, I would like to make a motion to find jurisdiction and that this document is public.
Second.
Is there any public comment?
In addition to that, can we determine that, oh, yes, you had
Jurisdiction,
it all, thank
yeah.
you. And to continue.
Oh, and to continue this item. We have a second. Is there any public comment on this motion?
Well, the fact that there's no representative from the city here is not a reason just to continue it because they're not here. The document was made public. It was a timely response. It was done on Friday. He got a notification on an automatic generated type thing saying they received it the following Monday, and it was a public document, so there's no violation.
Thank you. Can we take this motion by acclamation? All right, thank you.
Motion passes without objections.
Thank you.
Next on the agenda, item number 9, file number 17042, hearing to provide an opportunity for Andrew Bowe and the Arts Commission to discuss submitted complaints, standards of operation, and compliance with the Sunshine Ordinance in an effort to resolve the source cause of the complaints.
Thank you, Victor. So the reason that we have called this item today is to provide the parties with some type of alternative form of dispute resolution. We've seen a number of complaints filed by the complainant on these issues, and we think this could be an opportunity to find a resolution that might be a little bit out of the ordinary, but could be something that parties find satisfaction with, something that the task force itself, a resolution that the task force on its own likely wouldn't come to. We've seen actions from many parties that, where we find a violation, it doesn't really get the party the complainant what they wanted. A violation occurred, but the petitioner still doesn't get the information or continues to face barriers, things like that. As you know, so in this role, the task force will be acting more in a mediator, facilitator type of role than an adjudicator, as we have. I would like to let the other members say a few words, but my final note is going to be I would like the parties to think about, what would they like to get out of this today, and I'm asking for everyone to work in good faith of coming to a solution. Are there any comments from the other members? Member Wolf?
I'd just like to add that part of this also is, I think it raises a red flag for the task force, and it has in the past over many years, over many cases, where there are so many complaints against the same respondent for similar violations. And to just have it go on ad infinitum doesn't really get to a solution, even to possibly try to have training done. Some reason it doesn't get to a solution. And we never really are able to find out why that is. Now, we're not necessarily we like to provide training. We want people to be able to comply with the ordinance and with state law, so that we don't have to be engaged for such things that in that way. But at the same time, having so many complaints creates some difficulty for the scheduling of the task force, and so we feel in the public's interest to try to have a forum like this at this point, to try and come up with some either definitively find that there are some consistent violations or there are not, and some ways to find out maybe why they're happening, and if it becomes a technological issue or if it's a labor issue or whatever it is that we might be able to help, or at least figure out what the issue is and how it needs to become compliant. So lots of times we get cases that come up that are there's such a pattern that there's something wrong everywhere in the system of government, and and it's our duty to report that to the Board of Supervisors, so that possibly a law or an ordinance can be created to help alleviate that. And if that means the purchasing of some special software, then that's in their jurisdiction to do that, to try and so that the city maintains compliance. So I think there's a lot of good reasons to do this, and I think it's very beneficial. I think it's absolutely beneficial for the complainant, because they then get, for all the issues that they're dealing with, there's a forum now to address that, where in prior years we just go on ad infinitum and having huge backlogs, and everybody becomes unhappy. Mm-hmm. So I think this is a good first step to try to come to some solutions and resolution.
Okay, and to begin, I would like to give the complainant about 5 minutes to give, a summary of kind of, large-scale issues that the complainant is seeing. Of course, you can give a few small examples, but we are aware of the examples. That's why we want to give you this special opportunity.
Firstly, I'm opposed to mediation. I think that all the complaints that I file are legitimate violations. I don't understand why the Arts Commission keeps making the same mistakes over and over. That's takes a lot of my time to prepare these complaints. I see them. I go to the meetings. I see the violations while they're happening. Sometimes I say something, and there's that. So I don't want to mediate these open 9 complaints. I see a lot. They go into categories. First are the procedural violations for meetings, postings of minutes and agendas. They keep making the same mistakes that way, and that would be an education issue. Even though they're found in violation, the next day they make the same mistake. That would be failure to post the agenda within 72 hours of a meeting. That's a number of violations for the same thing. Failure to post the agenda of a passive meeting body and to allow members of the public to attend. There was just a violation from the clerks for that, yet the next day they did the same thing. The failure to post the 150-word summary in the body of the minutes, not at the end of the meeting. I attended the meeting. I said I read the summary. I handed it to them. That's the 3rd time they've made that same mistake. Sometimes I always give the opportunity for them to correct it before I file a complaint because it's time-consuming, and it takes a lot of my time. Then there's the public comment from people that weren't even at the meeting. They post their public comments. I think they need to be educated on these things. That presents 4 of the pending complaints, and they have a history of this. So a lot of this is, again, education. We know that a document request can go to any city employee, not just a generic thing, and not just to a public records or an information officer. Yet in the tone and the rants and so of Kate Patterson, even though I've told her that over and over again, doesn't happen. The file pending 17019 is once again a late response. They're very big on the late responses, and they blame me for it because it went to this employee and I'm supposed to know better, and because it's a variation of an email that I used before. I mean, it turns into I'm the terrible person, and that to me is mind-boggling. Another late response is 17068, and what makes it so tedious and unbelievably time-consuming for me is Kate Patterson makes a lot of mistakes. She forgets to send the PDF attachments a lot. So she doesn't want back and forth, but a lot of it, as of 3 hours ago, there was no PDF attachment. That's a big problem. She doesn't read the IDR. They could be 3 sentences, very clear and very direct. I get a lot of stuff that is completely unrelated to the IDR. That's a big problem. File number 17028, which is pending, is another late response. There were no documents contained in the attachment. Sometimes she sends the same documents 10 times, and I got to print them all out. I got to pile them up. I got to keep track. It's not as if she comes in with files and says this is what was sent, and this is not. It's nothing like that. So the issue of the rolling basis is a big problem. File number 17045. This was a fax that was sent at 2:20 in the afternoon. It should have been at least acknowledged by the end of business the following day. It wasn't. The documents that were supplied were not responsive, and they should have been sent on a rolling basis. When you talk about a backlog or duplicate complaints, all you have to do is just respond. That's only part of it. Page 222, I kind of outlined her whole aura, attitude, whatever. It's very rare that I get the documents that I request.
Thanks for all these clear points.
Okay.
Can we have 5 minutes for the respondent to respond?
Good evening. Kate Patterson, Director of Communications for the San Francisco Arts Commission. I just wanted to point out right off the bat, while we are here quite often, we're not always found in violation. So I just want to say that that occasionally we do make mistakes, but for the most part, we do respond with documents. I can't think of one instance where we haven't responded with a document without a legal justification. So we're not in a position where we're withholding information. We do make our best effort to get that information to the person. Occasionally we're late. I mean, we've tried a number of different protocols, some at the suggestion of this body to streamline our processes. The Arts Commission is a very small agency. We have limited staff capacity. I am a department of one person, and my primary role is the Director of Communications, so I do all the media relations and government affairs and manage the website, and I do a number of other things in addition to responding to information requests. So I think we've always been open and receptive to suggestions about how we can improve processes. I don't think this is an instance where we require more education. I do think that the issue that we have is that all of the requests that Mr. Boo or Ann Politatesh sends to us our immediate disclosure requests, which means that we have to stop whatever we're doing and address those requests no matter how busy we are, and that's very burdensome. I think that it would be very helpful for staff if she, it feels, the frequency and the fact that they're all IDRs, it feels like harassment. It doesn't necessarily feel like, she's just a regular citizen looking for information. And it also makes us feel that there's a total disregard for whatever we have that we're working on. And I think if she had a simple request and it wasn't an IDR, it would be a lot less taxing on staff to get her that information and to not make some of the mistakes that we have made in the past. She uses different aliases and different email addresses, so that's very hard for us to keep track of. Sometimes she'll send us the same request, but from different personalities, and so she duplicates or triplicates our work, and that is definitely difficult for us to keep track of all the details of all the various nuanced differences in these requests. She does have a track record of asking for the same things over and over again. I think I've been before this body at least 5 times to dispute our withholding of documents about how she harasses staff and commissioners. And that is also a big factor. Our whole interaction with her feels menacing, and staff is afraid of Mr. Boo. So I think that, she claims that I rant in my emails, but if you look through all my correspondence, I think you will see that I am very professional and stick to the facts and just provide her the information. I have on occasion created some boundaries where I felt that she was totally inappropriate, which she has been on numerous occasions. There are boundaries that your own Sunshine Task Force and the clerk of the Board of Supervisors have also put out there because of her treatment of staff. I sometimes do forget to attach a PDF because I'm a really busy person, and it happens. It doesn't mean I'm withholding information. It doesn't mean I'm trying to engage in a back and forth. I mean, the important thing is that I am providing records, and we have provided records. And it's false to say that we're here over and over again because we're not doing our jobs. I think we're trying really hard to do our jobs. We have tried to educate her and to let her know that the best, most efficient way to get a response is to email one person. But she showers a number of staff people with requests, which requires extra coordination on our part. Then she will send a fax, and how many people use faxes today? We don't use it that often. So, the fax sat in the printer for a whole day before it was noticed because we don't usually get faxes. I feel like I think that if I were to, the email evidence that we have provided over and over again, I think indicate that she does instigate back and forths. She does constantly send us IDRs, and I feel like if she were more thoughtful and considerate of our time and streamlined her request, that would be very helpful for us.
Before you sit down, I have a question for you. I'm going to ask the same to the petitioners. What would you like to get out of today? You came here, what did you expect to get out of it? You might have expected to get nothing, but what would you like to get out of it?
I would love for Mr. Boo to, if she has information requests, to send us one request a week with all of her requests, and then we would address that one request, not within an immediate disclosure time frame, but within a reasonable amount of time. It doesn't have to be 14 days, it doesn't have to be 10 days, but in a time frame that for a staff of very small capacity that can be achievable, allow us the time to make sure that we're thorough, given all that is on our plates.
Okay, thank you.
Sure.
I'd like to ask the same question of the complainant. Not to respond to her, but I want to know what you want to get out of this today.
What do I expect to get out of the meeting today?
I know that you oppose mediation, but you are here. You did fly across the country to be here. So can you identify what you would like to get out of this today?
It seemed at one point getting to the crux of the issue, and I think we heard it right here, the slander and the personal attacks. It's not within the Sunshine purview.
Exactly.
And I understand that more than anybody.
Okay, so maybe something that we could do for you. What could be within this could we get for you? Because I can't.
I would say within the past 5 years, most of my document requests revolve around this mindset of this individual. There were times when she was on maternity leave, when Rebecca Krill filled them, they were at least comprehensible. There were at least, the documents were more relevant. They didn't have this overtone and personal bias and accusatory nature, which leads to more document requests.
Okay. So it sounds like what you're saying is you would like the responses to be more specific and accurate to the requests that you have submitted. It sounds like that's what you feel you got from someone else who worked there.
Firstly, a number of staff were invited to attend this hearing today. I also invited 2 people via email, the Commission Secretary for the Procedural Issues and Rebecca Krill, who's, I didn't get any response. So the lack of interest on the part of the Arts Commission as a whole is a concern.
No, but for what you would like to get, it sounds like you said more accurate and specific responses.
I can say as an individual that, as you can see, she doesn't come prepared with documents ever. You might see her fishing around on the internet looking for the lost email. She's disorganized. She has some chip on her shoulder that involves me, and she invents a lot of situations that haven't happened. And I find myself lost in this morass of verbiage, trying to get to the heart of what is it that I've done that's been so bad, which is why I make
help you with that. But I want to find out what can we get you. I can't deal with.
If a person makes an
issue.
IDR, the standard issue is to send out an automatic. We received your IDR. We're going to invoke an extension, or we're going to get to it. Never happens.
Is that what you would like to get? I feel like that's not much, but
there is an attitude with this person. I don't even know her.
I can't do anything with the attitude. And if all you want is a response to your IDR saying that they're going to invoke an extension,
I would like the documents that I requested. I don't have to give you the reason why I want them.
I didn't ask for that, but I'm just saying.
But there's a reason why they are IDRs. I do not send the frequency that she suggested, and I don't see any evidence towards her claims. And rather than continue in this mindset of if I do get documents and I read through it, a lot of them are repetitive, the same thing.
And not responsive?
They're very rarely responsive.
Okay, so you're looking for more specific, concise responses to your requests?
I am making very specific document requests. It might be, can I get a little more clarification from you? Can we narrow the scope of this request?
Is that what you received from the...
Never.
No, I mean...
absolutely never.
No, not from her, from Krill. Is that what you were getting? Is there something that was going on with your interaction with her that were you getting more questions for clarification?
I think it was
Was it a table that they were provided, like in the form of a table?
It was a 6-month period when I think she was on maternity leave. Mm-hmm. And then prior to that was Howard Lazar, who really could not write. He couldn't stay on topic.
Right, but was Krill giving you responses that were maybe organized in a specific way?
Her writing was more organized. It was more focused. It was more...
Is there a table or anything like that to clarify, like...
Well, with
The
regard
response
to your
to one.
first request, da-da-da,
Okay.
the second part, da-da-da,
Okay.
we're invoking an extension. With Patterson, I've even gotten on the letterhead, we do not have to respond to you because the city attorney said so, and then you have a link to the city attorney's office. That does not meet the bar of any, what is she claiming? Informant privilege?
Okay.
All this conglomeration of stuff. What am I hoping to get? What anybody might hope, to get the documents that they need.
I know, but it's not just to get the documents. They need to be like in a format that they understand and clearly responds to the request. 'Cause
I spend the
is that what you mean?
I would say up until a few hours ago, I'm constantly checking email because, oops, she forgot the PDF. Oops, this one's not responsive. Oops, this one's this. And there are times when I get 20 to 30 emails a day from her. And then I get these memos. She's perceiving that I'm menacing. Well, a perception is something in her mind.
Right, but I'm not, I did hear her say that. I'm not taking that into
It's the
consideration.
whole-
I'm talking about the specific format for the responses. You said before you were getting from someone else maybe responses that were,
They were clearer.
organized in a way
They were
that
clearer. They were more organized. They were
briefer maybe.
much briefer.
Okay.
And they were really to the point. It didn't have this really serious attitude problem, not this accusatory mushmash of nonsense.
Okay, but I'm trying to
I don't
focus
think
on,
Ms. Patterson knows anything about me, and I certainly don't want to know anything about her. She's personalized this.
yeah,
I don't
and
know why.
I'm trying to really not
I don't
have
know
that
why.
part.
I can't tell you. I have no idea why.
That's okay. I'm not asking why, but I am putting all of that aside to try
Good,
and
thank you.
identify what has worked before, because it sounds like some things have worked with the other person.
I think,
and we can try and use some of that.
Member
information.
Wolf kind of hit on it. Before I arrived on the scene about 5 years ago, there was a long history with the Arts Commission of other people, similar type issues, a lack of transparency, late responses, meetings, minutes, that sort of thing. People going over there, having problems, asking questions. I did not suddenly appear when I arrived. It's been going on for a long time.
Thank you.
For Kay Patterson not even to acknowledge that she would like some kind of education, or she can't handle this, or she doesn't know how. At the technology meeting last month, I was quite astounded to believe that all a department had to do was reach out to them and they would seek to educate them directly across the street.
Thank you. Are there any other questions for members? Member Hinsey? Okay. Thank you, Ms. Trabue. So right now what I feel like I'm hearing, I think from the complainant is, a need to receive responses, of course, in a timely manner, but maybe organized in a way that makes it clear what of the many documents that might be received is actually responded to. It sounds like something that an EOTC checklist might be helpful, like, is the document with the responses attached? Are the documents that are attached specifically identified as responding to specific questions? And maybe this kind of standardization in this case, it's not something that I know of us doing, but could be helpful to the complainant. On the side of the respondent, it sounds like they are feeling a little bit overwhelmed by the number of requests that are coming in. Also, documents that are being requested potentially multiple times. It's okay, but I have a response for that. I think that if there is confusion on this, and so the complainant is saying, "Well, I have not made the same request." Well, that means the respondent is interpreting a request incorrectly as being the same request when maybe it is different in some way. But I think that if there is maybe some type of a uniform format for responses, where the document is specifically identified for the request, and then the document that's being attached is numbered or coded in a way that specifically responds to the request. Then there won't be confusion about this is the same request as before, something like that. So I'm just trying to think of, in my experience, the agency where I work at, we've had issues in the past, and we've worked on tools to deal with this, where maybe multiple parties are requesting a document, or one party has requested a document. The agency has gone through the whole process to determine that the document is public, that an investigation is closed, etc. Then someone else asks for the document. And then we went through that whole process over again. Well, that's a waste of the second person's time if the commission has already publicly determined that document is public, etc. And so they've been able to publicly post the requests that are coming in, as well as, if it's been responded to, the response is also posted online. It sounds like the Arts Commission is a small agency, so they might not be able to institute all of these things, but in some way that could possibly be used. Member Wolf?
So it brings up some questions for me with regards to the capacity of the commission. And in the past, when we've sent departments or agencies or what have you, whoever the respondent is, to the Education Outreach and Training Committee, they've kind of devised or came up with a custom solution, because everybody's a different situation. And also people are budgeted differently, that kind of thing. So with that, I want to ask Ms. Patterson a couple of questions.
I forgot 2 points.
So
When he's done questioning Ms. Patterson, we can give you an opportunity.
So I just I'm going to kind of do a little bit of the work that the EOTC committee questions they would ask. Okay, so first of all, is there like a separate department that the commission oversees? Is there an arts department versus the Arts Commission? For instance, the planning, there's a planning department that manages all the permits, all the blueprints and everything. The commission doesn't do any of that work. They just oversee the work of that department. Is it the same kind of setup as yours?
Yes, we have an Arts Commission that's a body of 12 commissioners appointed by the mayor that oversees the work of the Arts Commission, which has a number of programs: street artist licensing, public art, a grant program, civic design review. So yeah, we have a lot of different programs at the agency.
So there's an agency and then there's a commission?
A commission, correct.
Okay. So most of these complaints were around the commission, not the agency, correct?
There's a variety of complaints.
Okay.
Some are related to commission meeting minutes and agendas and whatnot, or including the statement in the body of the minutes. Mm-hmm. Some of them have to do with other members in the street artists program, very specific requests for files on different street artists in the program.
Is that agency
That's
related?
agency,
Okay.
yeah. Most of the requests are agency related.
Okay, so the thing is usually the agency is far better funded than the commission.
Well, they're one and the same. We don't have a separate, we have one, the commission secretary is the only staff person of the commission.
Is that from the clerk of the board's office? Does the clerk provide that?
She's in our
hired?
agency, yeah.
Okay, she's hired. So then, I guess the question has to come down to if there's a requirement under the law to provide this service to the public. If the agency or the department, the commission, the body, whatever it is unable to do so because of a capacity reason, they're urged to expand that to try and meet that. Now, if there's a cause or a reason that is whatever is happening that is causing maybe an overload at a particular time, that's good reason to have a discussion about what it is, because maybe the way things are being presented, maybe the way records are kept. It could be a communications issue. It could be any number of things, okay? But the idea is to try and repair the problem so that the public is served appropriately. Now, I understand there could be at times an overabundance of requests. Now, as far as the Sunshine Task Force is concerned, in the number of requests that are made of the city every day, every week, month, year, the number of violations that we get is infinitesimal. I mean, just compared to the planning department, the number of information requests that they get is very, very small. Now, granted, the planning department is obviously probably better staffed, more staff. They have more money because of the fees and what have you they collect. But I think there has to be some diligence. It's not diligence on completing the request, but it's diligence on making sure that it can be amply done, so that way it doesn't all fall on one person. And that is a command decision by the director. That is not a command decision by the staffer.
I think I need to clarify what our process is. So when we get a request, and 99% of the time it's for documents that are related to the Street Artist Program, because it's a program that historically Mr. Boo has participated in, although she does not currently have a street artist license. I get the request.
So I just want to say, we can do away with direct comments. We want to keep our focus here specifically on the
Fine. Let's just make sure that that's equitable. So I'm just trying to explain that when we get a request for a document that's related to the Street Artist Program, I have to rely on that staff to do the research, because it's their files in which that document exists. They oftentimes will draft a response, which I'll review, and then they'll send me the records, and then I'll send it out. So the idea is that I am the primary funnel through which these records are disseminated. So it's not necessarily that it's all on me. It's not necessarily that. And I think I'm starting to get upset, because I feel like the premise of this conversation is that we're not providing documents, or that my responses, which do include legalese, because oftentimes I have to invoke legal language, are not adequate. And I think that if you reviewed our responses, you would see that they are thorough and adequate. Yes, sometimes they are late. It happens, and we do our best so that that's not the case. But I just feel like you guys have seen me, you've seen what I've prepared on numerous occasions. And so if you want to look back at my responses and say, hey, Kate, I think it would be better if you did this, this, and this, I'm totally open to that feedback. But I feel like right now, the way I feel is that there is this presumption that our responses are inadequate or not professional or not thorough, and that is totally not the case.
I don't think I or anybody else has made a judgment or expressed the judgment. We're just trying to get an idea of what's happening. And this is not the first time that a situation like this has come up before any other agency. Rec and Park has been in this room. I can't tell you how many months of meetings were only about Rec and Park. And Rec and Park, they created a kind of a protocol in order to make things happen. That's Olive Gong. So Olive Gong does this, that she's the same funnel that you are, but she only responds to general requests of Rec and Park, of the department, or of the commission. Everybody else is responsible for their own requests. And that's the way it works. I mean, that's kind of the best way it works, and we would absolutely suggest that at every turn because the ordinance is written that way.
Right, I hear you. I will say that historically it was handled that way, and it seemed to be problematic for this body that it was handled that way. So I think that
A problem for this body?
For this body,
Why
yes.
was it a problem for this body?
Because this kind of predates when I really assumed this role, but I think that Mr. Booth cited Howard Lazar. I mean, because again, I think the primarily the complaints that you see that are related to the Arts Commission have to do with the street artist licensing program. So I can't speak to what occurred before, but it was very much handled that way, and it seemed that when we shifted, I think that things did in some ways get better in terms of our response time and et cetera. So I will just say to Chair Tisify that we are going to be participating in the next request pilot program. So I think that will provide a better organizational rubric, which may create some efficiencies. I don't know.
This is the software platform.
It's the software platform. It's used by the City of Oakland. And there's a number of agencies who are participating in a pilot. Whereas now we're just using an email platform, which I think, I think it can be difficult because you're trying to organize a bunch of information within a platform that has a bunch of information that's not related to an information request, whereas Next Request, you kind of log it into a system.
That's
it's a
the one I was
separate
talking
entity.
about.
Yeah, Next
that's
Request.
what my agency is using now.
Yeah.
So, as of 6 months ago.
So we will be doing that. So that would be great to see how that goes and evaluate that with you. I mean, certainly we won't continue if it's unsatisfactory.
Right. So, beyond the numerous requests and complaints that Ms. Trudeau has with us currently, which we will to have some discussion about, if it was not just one person, but a multitude, let's say all the, each individual street artist filed requests for information about, whatever. I mean, you became overwhelmed. I mean, how do you deal with that? I mean, is it left to be incumbent upon you to figure it out, or are you able to provide some feedback to management that the current system isn't working and something needs to change or what have you? I mean, the bulk of the issues here are mostly on time frame and and documents, whether they're responsive or not. They're not really outrageous, violations that we're used to seeing from various other departments.
Right.
So this is kind of why we're a little curious about what's happening. And frankly, by the same token, if the agency and the commission is like somewhat one and the same, so we could take it to say, let's treat it like the Ethics Commission. Ethics Commission is a huge department. They got lots of staff, do tons of investigative work, and it's all under the auspices pretty much of the commission. The commission is the one that gets funded. There's not an ethics agency or an ethics department kind of thing. So the next question I would say is let me see your budget. And, I'd like to see where, how it gets spent and whether is there a line item set aside for this particular activity that is required by law. And if it isn't, and it's not equitable, it's not providing enough equity to the general public to know what your agency is doing, then that is a discussion worth having, I think.
I think that certainly management would be open to exploring different processes. That's, it's a very collegial environment, collaborative. I think that, everyone is invested in not having me be here
Yeah, I
one
hear
to
you.
two times a month.
I just feel that management that has shown up here has not been willing to budge on any of that.
Well,
so whether the staff, the understaff is collegial, they're not the ones that get to request the money or
right,
spend it. So.
Right. Well, what I will say is that, again, we're a small agency, and I can say that in this budget there isn't extra money for another staff person to help handle this. I mean, I don't think that the volume necessitates that, for example.
Okay.
I will say that, again, I think that some of our issues related to tardiness are because, and we've worked through them here, where we think we have, like where the person gets she sends me a request and I'm out of the office, and instead of going to the person that's designated in my out of office, I get there's a complaint registered with that. So yes, that means we're tardy. I understand that. But at the same time, it's not because, and so we've shifted systems, but that's not because we're disregarding the requests and we're late. I think that or it comes in at a fax, which we never get faxes. So, that's not something we check more than, once a day. So there's these little things that I think have created what appears to be a track record of tardiness, when in fact I would say that the majority of the time we are on time, we are thorough, and we provide all the documents requested.
Okay.
So I just feel like the perspective, and I don't mean this to sound overly critical, the perspective of the Arts Commission I feel like is skewed, because I feel like every time we are constantly brought before this body for what I consider to be minor infractions, because the bottom line is we always provide the documents unless we have a legal reason why we can't do it. So I think, again, for us, if we can consolidate the requests, we get requests from other members in the Street Arts Committee, and they're not immediate disclosure requests. And it's really helpful for us to not have to scramble and to be thorough.
But by the same token, the allowance for the extension. Let's be clear what an IDR, the process for IDR is. When somebody sends you an IDR, the response is not necessarily for the actual documents. The response is just that we received it. Okay, we will get to it in this particular time frame, or we're invoking the full 10 days. The 10 days is the same period of time as if it was a regular request.
Okay, well then maybe we go forward and we just invoke the 10 days going forward.
If you feel that it's needed, sure. Okay, if you could exercise it all the time if you like, fine. But it's the point of it is the reason why the IDR was created. One of the reasons that the framers of the ballot initiative found that it'd be important was across streets the court, lawyer or a defendant or somebody needed a document from the city because of a court case. They needed it within a 24-hour or at least a 72-hour turnaround time. So the IDR gives it a little bit more gravity. Okay,
I totally get that.
Granted, I hear people read and interpret laws in different ways and use them in different ways. I get that. I'm not making any accusations or anything. I'm just saying it happens, okay? But the basis for that invention was for that purpose. And frankly, there are other things. The Planning Commission, things get fast-tracked pretty quickly. There's, we have the whole issue some years ago around the expediters and the planning department.
I absolutely follow you, yeah.
So, that is kind of the purpose of it. Now, granted, the law doesn't specify the ability to ask what the intent is. There's only one place that it does that, and that is only for redactions. That is the only place in the entire law, even state law, for that a respondent can ask the requester why they want this information. And it's not to be judged, it's just to determine which information would then need to be redacted for that purpose.
Sure.
Okay.
Yeah, we never ask, we just
I
give.
know, I know,
But
I understand,
no,
but
it's
just
good.
saying.
I think that
So-
I think that what we can do, so we don't feel this incredible time crunch, especially during busy times, is we'll just invoke the extension. We'll respond within the 24-hour time period saying we received it, and we'll just have more time.
Okay, thank you.
Thanks.
So we have about 15 minutes left. I would like, Victor, can you give Ms. Trudeau 2 minutes? Because she's been waiting patiently. And then we can use the rest of our time. We will discuss among ourselves maybe what next steps would be.
There's a couple things. Firstly, education. She's been lectured before about what an IDR is. This is not the first time. And all of her promises seem to fall through the next day. I can't figure it out. Maybe a new custodian of records might be a good idea. There's probably 40 employees there. So oftentimes, very often, I will get a response within 3 seconds of sending it. 3 seconds is not enough time to do a search, to identify what documents are available, to identify which documents they might possibly withhold, or to identify which documents might possibly need to be redacted. This is common practice. This happens with every single document request. There is no way these procedures could be followed within 3 seconds. The issue of redactions is a big problem. I've gone before the Arts Commission more than 17 times, showing them evidence on the overhead. Oh, here's Jill Manton's cell phone number. Oh, here's a commissioner's cell phone number. Here's this. So there really is no oversight between the commission and the agency. They just don't want to be bothered with you, and it's just that simple. So, as far as how the original IDR gets twisted and turned into something else, that's a mystery to me, because when you have something written, it's very clear. How does it become, oh, your request was for this and this and this, and it's not even remotely related to the original IDR? That's a big problem. Then most of my document requests concern these allegations that are made against me. I know that I'm not doing the things that are, and there's no evidence. So how could there be documents? That's it.
Thank you.
So I think this is, informative for me to at least get a kind of an idea of what's going on on both ends. I think we need to dispense with how to dispense with, not throw away, but how to proceed with the existing cases that are before us. And I think I was kind of hoping that there would be some more discussion about that, but it didn't seem to naturally come up. So, we have a job, our duty to adjudicate the cases that were before us. The question is how and what procedure in order to do that, and in order to also be fair. So I think it would be helpful to know which cases could, like, if there were multiple cases, what we would normally combine a case to be. Whether we could first deal with that, and whether then that maybe some of the issues have been alleviated in some way, that other items could be moved off the docket. So I think we'd have to engage Ms. Trudeau a little bit more to determine those things.
Engage in the process like this, or in a different type of process?
I don't, whatever is convenient, in order to do that. But I think because of the amount of, how many, do we have
I think we have 9 pending.
9 pending? Okay, so, that, we couldn't get through an entire meeting for all of them. So it would probably it would take 2 months. And we, at the pleasure of the task force, they really want to, kind of see more variety of cases, so they really only want to hear from two complaints from the same person on the same agency. So that's, we kind of have to find a balance so it works for everybody. So.
Should we do like consent calendar of the market? Does it work?
Well, the thing about consent calendar is that it's somewhat the same as combining. So you're basically saying we're going to vote on all these items together, and there will be like one public comment period for all the. You're just voting on a bunch together. It's not. Right. It's not really. I'm not suggesting consent calendar. What I'm suggesting is finding some resolution on. Let's look at all these 9. Which ones can be combined? Which ones can be withdrawn? And I think that is up to the complainant, since the complainant is the petitioner, is asking the task force to take these on. And this is somewhat in the interest for the task force, so they can serve the public properly, so it doesn't create such a big, huge backlog, and to identify what the issues are, so that these same things don't, because it may not be Ms. Trudeau in the future. Mm-hmm. Since she doesn't live here, it could end up being somebody else that lives here that all of a sudden there's another big abundance. But the problem, if there is a problem or the concerns that come up, whatever the thing is that a petition for a hearing comes to us in an abundant way, mm-hmm. that we're going to have to deal with that in some way, shape, or form. And I think it's a kind of incumbent upon us to try to deal with that. And when that happens, usually, if there's a problem, and this is I'm not focusing on the Arts Commission, but any department, if there's any department that is continually like disregarding or, things are just not working out with this, then that's a problem. Mm-hmm. There has to be something fixed. And if they can't be fixed or they refuse to fix it, then it's up to the Board of Supervisors to say, you know what, you either fix this or you're not going to get funded. Mm-hmm. And that's essentially is the lever that the task force has to try and bring people into compliance. I don't necessarily. I think this issue could be dealt with. I'm not suggesting that. Plus, we're beyond the budget period anyway at this point. But but I think we should look at, if there's just 9, I think if we can have a short conversation about which ones could be combined, which ones you may feel comfortable maybe withdrawing. We would like to maybe deal with all of them, maybe try to get them in one meeting.
One complaint committee meeting or one full meeting? Because I thought we already discussed that. The members want to hear, at most 2.
Right. So I'm saying if we can combine them down into 2, if they get, if there are some that are all in the same rubric that can be combined into 1, and then if there's one other or the others could be withdrawn, whatever, just to move this along. I think I'm not going to speak for Ms. Patterson, but I'm just going to say I think the Arts Commission is hearing what's happening here, and we're trying to find some resolution. We're not going to, we're going to follow up with this. We want to make sure that I think our best job is not to find any kind of punitive, like we don't want to find necessarily fault per se, but we want the city to comply. That's our ultimate goal, is to assure that the city complies with the ordinance.
Yeah, finding violations on their own is not really helping the complainants or the public get what they need.
Right, unless they're willful. I mean, that's different.
Right.
So it's,
Right.
and we've dealt with those before, so.
Ms. Trudeau, do you feel comfortable at this time whittling your complaints down into 2 categories? Or if you would like, I can give you a date by which to send that in via email for us to consider or to start reviewing.
Let me preface this.
Because we're ending at 7:30. So that's
Firstly, we're not hearing any, I'm not getting a solid idea that the Arts Commission is going to suddenly change. New platforms, columns, it's not going to change. And every time I walk out of this meeting room, I walk away with that idea. I'm the one who's filing the complaints, but there are many, many people that would love to step up and do the same thing. There's changes going on within the street arts program. Howard Lazar finally resigned. I had to ask a friend of mine who volunteered her time to get some information about the vacancy. Is it going to be a job cut or what's going on? Because the IDR I made didn't even nearly address the documents that I requested. I got a retirement party, a proclamation. I mean, all somebody has to do is read. So I definitely don't get the idea that things are going to change there. If you order them to go through education and outreach, and give them a timeline to comply with the various issues, then I would get an idea and probably reduce this. But I can tell you it's not, it might stop from me, but there are other people who are filing complaints. I'm not the only one.
Okay.
They're not a transparent agency. They don't pick up the phone. They don't answer questions. There's not a lot of meetings.
Thank you. So today's June 27th. I would like to give Ms. Trudeau until July 11th to look through her complaints and organize them into 2 categories. I'm not sure how we will dispense of those. I'm not saying they will necessarily all be combined. That's something that you'll have an opportunity to, comment on to help us come to a determination on that procedural matter. But
I can do it right now.
I would like to have it in writing, and I would like you July 4th, July 5th or July 11th?
11.
Okay, so July 11th to have those 9 complaints in writing, separated into 2 categories, and please just send that to Victor Young.
And what should the categories be?
They will be your determination. What are the 2 elements that are connecting, that are surfacing here? Like, are there 5 that have to do with meeting notices and 4 that have to do with record requests? That's an example of, 2 different categories. Or if you see something else, then you can also make that determination for submittal.
Can I make a request that all this slander and personal attacks stop? It's not really sunshine.
I know. As I said earlier, I agree. It's not sunshine.
It's gone on for so long.
Thank you, Mr. Boo. And I recognize that, and you've mentioned it several times, and I have acknowledged that I'm hearing what you're saying. Those aren't coming into consideration with, how we're dispensing of your case. So,
okay.
Thank you.
I just want to add, too, that I would say that, yes, the Arts Commission and the agency will be engaged for some sort of training, or at least some sort of discussion about it, because I think it's important just to find out what's happening. And we'll follow up with whatever software platform that you're using to assure.
I don't think that's the issue.
I hear you, but that is what you just asked for. So I'm going to,
I'm asking,
like I said, I'm going to extend, I just want to extend that to you, so that I will make sure that
I
happens.
believe, along with several other people who have been in this room as complainants, that for some reason the Arts Commission has a chip on their shoulder. In my situation, it's something personal. I don't know what it is. I don't know how to get it to stop. All this individual has to do is sit down, spend the requisite 10 minutes it takes. That's about the time that's allowed to fill a document request. All you have to do is read it. If you're asking for interdepartmental emails, it's not a proclamation. If you're asking for, just read it and fill the document.
I understand. I heard you say something. I was responding to that.
Yeah,
so.
okay.
Thank you. So can we close this item?
Yeah.
Would you like to table it or file it?
I would like to table it. Is there a motion?
Let's do it in a correct parliamentary procedure. It would be postponing it to a future date. Because we're going to adjourn today, and anything on the table would then
Be
die.
cleared. Okay, do you want to make a motion to that effect?
Yeah, move to postpone it to, and then the next complaint committee or whatever.
How about the next?
Can we
complaint?
continue it to the call of the chair?
Yeah, we could do that too.
Okay.
Yeah.
Okay, so the 11th.
On July 11th, send your ideas to Victor on those 9 complaints. Thank you, Mr. Vu. Is there a second?
Second.
Can we take that by acclamation?
Public comment.
Yeah.
Do we have any public comment on that matter? Seeing none, can we take that by acclamation?
Yes, the motion is adopted without objection.
Is the next item?
Next on the agenda is item 10, announcements, comments, questions, and future agenda items.
I have none. Any of the members? No. Can we call the next item?
The next item is adjournment.
Move to adjourn.
Second.
Take that by acclamation. Thank you.